How to legally end a marriage. Hello, everyone, and welcome back to our channel. Today's topic is a sensitive one, but an important one to discuss. We'll be talking about how to apply for divorce in the United Kingdom. Divorce can be a challenging process, and knowing the steps involved can help you navigate through it. So, let's get started. This guide describes the procedure for legally terminating a marriage by obtaining a divorce. Criteria for starting divorce proceedings. Before divorce proceedings can be initiated, a couple must have been married for at least 1 year. The application can be submitted by either spouse individually, single application, or jointly, joint application. In singular application, the person initiating the divorce proceedings is referred to as the applicant, and the other spouse is referred to as the respondent. While in a joint application, the petitioners are both spouses, and there is no respondent. A joint application can be converted to a sole application if one of the spouses determines they no longer want to pursue divorce proceedings or refuses to move forward with the case. However, a single applicant application cannot be converted into a joint application. To initiate divorce proceedings in England and Wales, the applicants must satisfy at least one of the jurisdictional criteria, which are based on the residence or domicile of one or both parties to the marriage. Habitual residence is difficult to define, but it is typically where a person spends the majority of their time and where their centre of interests is located. Domicile is also difficult to define, but generally speaking, a person is domiciled in a country if they regard that country to be their permanent home, even if they reside in another country. There is only one ground for divorce, and that is irretrievable breakdown of the marriage. If you believe your spouse may also want a divorce, you may wish to discuss filing a joint divorce petition. If you decide to pursue a divorce, it is customary to send your spouse a copy of the draft application for divorce before filing it with the court. This enables your spouse to voice any concerns they may have regarding the application's content. Before initiating legal proceedings, you and your spouse may wish to reach an agreement regarding who will pay the costs or how you will split the costs. Divorce procedure, sole application. How do proceedings begin? After the sole application has been perfected, it is submitted online to the court along with a copy of your marriage certificate and the court fee. In the application, a statement of truth confirms that you attest that the contents are true and that you understand you could be held in contempt of court if something is not true and you knew it was not true when you gave the statement of truth. The court then issues the application initiating divorce proceedings. Seeking costs. In general, judges discourage applications for costs unless a respondent has delayed the divorce, for instance by evading service of the application, causing you to incur unnecessary costs. In a straightforward matter, it is recommended that each party bear its own costs. In an uncomplicated case, the costs application must be made at the same time as the application for a conditional order if it is appropriate to apply for a costs order that your spouse pay your costs related to the divorce proceedings. Who notifies my spouse that I have filed for divorce? The issued application and other court documents are then served on your spouse or his or her solicitors. Service entails sending the documents via a method permitted by court rules. The documents must be served within 28 days of the court's issuance of the application. Within 14 days, your spouse or their solicitors must then complete and submit to the court a document known as the acknowledgement of service. This can be done online. Your spouse confirms receipt of the application within the acknowledgement of service. A respondent may contest the divorce, but only on very limited grounds, such as the validity of the marriage. If your spouse contests the proceedings, there will be court hearings to determine whether the divorce proceedings should continue or be dismissed. Applying for the first stage divorce order, conditional order. A divorce order is made in 2 stages. 20 weeks after the divorce petition is filed, if your spouse does not contest the proceedings, you can file for the conditional order, which is the first stage of the divorce order. In the application for the conditional order, you must state that you desire to proceed with the divorce and that nothing in the divorce application has changed, or, if anything has changed, you must specify what has changed. Applying for the final order of divorce. Once 6 weeks, and 1 day, have passed from the day the conditional order was made, you can apply for the final divorce order. This brings your marriage to an end, and you are then formally divorced. However, you should not apply for the final divorce order until any application for financial orders has been resolved or agreement has been reached about financial matters and the agreement has been made into a court order. If you do not apply for the final order, your spouse could apply, but only after 3 months from the first day you could have applied. Divorce procedure, joint application. How do you start proceedings jointly? Before issuing the joint application, the draft application is sent to your spouse or their solicitors to check over and add any details that are necessary. The application is then sent back to you or your solicitors to review any additions. The draft application can go back and forth in this way before it is finally submitted to court to be issued. Usually, the solicitors for each applicant discuss the contents to avoid the application going back and forth. When the joint application has been finalized, it is submitted to court together with an image of your original marriage certificate and court fee. A statement of truth is included in the application for both you and your spouse. This confirms that each of you attests that the contents are true and that you each understand you could be held in contempt of court if in fact something is not true and you knew it not to be true when you gave the statement of truth. What happens once the joint application is issued? On issuing the application, the court produces a notice of proceedings and emails and posts this to each applicant or to their solicitors. Each applicant must acknowledge receipt of the notice of proceedings within 14 days from the application being issued. Applying for the first stage divorce order, conditional order. A divorce order is made in 2 stages. 20 weeks after the divorce application was issued, you and your spouse can apply for the first stage of the divorce order, called the conditional order. In the application for the conditional order, you must each confirm that you wish to proceed with the divorce, and that everything in the divorce application remains unchanged or, if not, what has changed. If one of you no longer wishes to apply for divorce or simply refuses to progress the divorce proceedings, the other applicant can make the application for a conditional order on a sole basis. The application then becomes a sole application and that applicant can then make the application for a final order of divorce. The spouse who is no longer participating in the proceedings is called the respondent from this stage of the proceedings. Applying for the final order of divorce. Once 6 weeks have passed from the day the conditional order was made, you and your spouse can apply for the final divorce order. This brings your marriage to an end, and you are then formally divorced. However, you should not apply for the final divorce order until any application for financial orders has been resolved or agreement has been reached about financial matters, and this has been made into a court order. If financial matters have been resolved, but one of you at this stage no longer wishes to apply for divorce or simply refuses to progress the divorce proceedings, the other applicant can apply for a final divorce order. However, that applicant must first formally inform the other spouse of their intention to make the application. They can only apply for the final divorce order 14 days after they have informed their spouse of their intention to apply. This is to allow the other spouse an opportunity to apply to court to prevent the final divorce order being made until financial matters have been resolved. Finances. When a divorce application has been filed at court, either party can apply for financial orders. The orders available in financial remedy proceedings include the following: periodical payments, also known as maintenance; lump sum orders; property adjustment orders, altering the ownership of property, for example the family home; pension sharing orders and pension attachment orders. If you found this video helpful, please give it a thumbs up and consider subscribing to our channel for more informative content. Also, don't forget to hit the notification bell, so you never miss an update. Thank you for watching, and take care. See you in the next video.